Malad just Chaudhary. I such and such will not be then address. This lodged this written complaint against a reporter anchor named Shuddhoshil of Priyobandhu Bangla Media, uploaded and circulated an offensive video against the Honorable Chief Justice of India in pertinence to the matter of RG Court, which the Supreme Court took mention above, prepared a report and circulated the contents through communicable devices that are very much offensive, defamatory, and address the Honorable Chief Justice of India is very disrespectful, and the full content of the said news report circulated by the annoyance, inconvenience, insult, injury, and criminal intimidation. Actually, this is the case. There is a lot of circulation and publication on the YouTube channel.
Why don't we first see the order?
I am just referring to why this case.
Yes.
This in the said YouTube channel, there is a video which has been published and circulated, which is very derogatory and malicious and tarnishing the Honorable Chief Justice of India. There was a video. In that scope, FIR has been lost. Now, kindly see the first. I will take up the what is the contents of the FIR, then the the court below order. The MAT application, sorry, can 1, can 1, at page 50. Can 1.
Yes.
Kindly see the FIR is on 13/9/2024. Kindly mark the date, kindly. Then the sections are 267, 352, 353, 1B, C, subclause 2 of the BNS. I will read later on what is the corresponding section of the I. For the moment, I am not. Next page, 60.
May intervene
No,
for a
16,
moment,
1/6.
That is of can 1.
Lordship.
Yes,
Lordship, am I audible, Lordship?
Can
Yes, you are.
Only thing is that may I intervene for a moment. Lordship, may kindly see the order once.
I will.
That
Of
will
course.
apprise your Lordship.
Yes.
yes, sir. The I such and such. Lordship got it. Just Chaudhary. I such and such will not be then address. This lodged this written complaint against a reporter anchor named Shuddhoshil of Priyobandhu Bangla Media, uploaded and circulated an offensive video against the Honorable Chief Justice of India in pertinence to the matter of RG Court, which the Supreme Court took suo motu cognizance of the matter. The reporter anchor has mentioned above, prepared a report and circulated the contents through communicable devices that are very much offensive, defamatory, and menacing in character. The manner in which the reporter addressed the Honorable Chief Justice of India is very disrespectful, and the full content of the said news report circulated by the reporter is false and caused annoyance, inconvenience, insult, injury, and criminal intimidation. Whereas the reporter anchor intentionally made the false report by distorting the original fact and misrepresenting the false information to create enmity and hatred towards the society. Not only that, the media with malafide intention circulated the news report challenging the power of the Honorable Chief Justice, and also in imaginary way threatened the public to agitate against the Honorable Chief CJI solely. That the said circulation report, where the reporter anchor alleged that the Honorable Chief Justice of India is not performing his constitutional obligations by delaying the process of justice to the public of nation. It was also alleged by the reporter that the Honorable Chief Justice is working as per his own hidden agenda, and the CJI is intentionally lingering some cases, legal issues, according to his own sweet will, without considering the gravity of the cases and law of the land. That the reporter even alleged that CJI is acting biasly in some selective issues. Thus, by circulating the said video, the anchor intentionally, next page, insulted the CJI of the country and the entire judicial system of the nation by provoking the public at large, which shall break the public peace and tranquility, and created feeling of hatred, enmity, and doubt among the minds of the people of this nation. That the reporter anchor had stated in the report that the Honorable Chief Justice of India is the most tarnished CJI ever in our judicial history, and the Honorable Chief Justice shall immediately be impeached from the chair. That the reporter also stated that the hearing of the matter RG Court will not be listed before the Honorable Supreme Court, and RG Court will not get justice until the Honorable Chief Justice is impeached from the acting CJI. That the entire report news is fake, which was circulated on social media to intentionally defame the Honorable. This is the content that was published in his own the YouTube channel. It has been circulated. There are lakhs and millions of people of the viewers. This video has been circulated on 2nd September. RG Court incident took place on 13th August 2024. 9th August. 13th August. Anyway, what is the date? 2nd September, this video has been circulated, uploaded. 13th September, this affair has been lost. Just after 10-11 days.
After how many days? This affair was
10-11 days.
in 11 days.
Yes. 13th September, this affair has been lost.
Yes,
2nd September, this uploaded.
that is
Published.
published.
Yes. And kindly recall, my lord, in entire state, even across the country, even there was this so my lord anarchy with regards to this RG court situation.
Admitted.
Now, my lord, the now, my lord, kindly now come to the sections. My lord, what might it is troubling me and why I am agreed by. This is the reason I am coming. I am getting cut short in the matter. My lord. 267, 352 remain as 267, 352, 353 surplus 1 B C
এই
2.
দাও না বিএনএস টা
My lord,
এটা সিআরপিসি টা ওনাকে দাও বিএনএস এই
ভারতীয় ন্যায় সংহিতা এই যে না না ন্যায় সংহিতা
এসিটাকে একটু বন্ধ করা যাবে?
এইটা
এসিটা একটু মুখে লাগছে বা উইক সাইড উপরে তুলে দেওয়া যাবে।
Yes.
Yes, my lord. Section is 267, 352, 353, 1BC2. My lord, first I will read 352. 267 I'll come later.
252,
352, my lord.
352.
কি ছিল এটা বাবা ভারতীয় ন্যায় সংহিতা তো
My lord. I hand over my book, my lord.
ইয়েস আই থিংক সো
But it is marked, my lord. I'll kindly be excused, my lord.
352 পাওয়া গেছে দেখতে একটু চলে আসছে 347
আমার
ও কি এই বইটা কোনটা দেখছো
একই তো ন্যায় সংহিতা আপনি 353
Well, Lordship, this matter, Lordship, can be cut short. An argument could be advanced by citing the order itself, why the order was stayed, why the FIR was stayed.
Oh, 151.
ইয়েস
Lordship got it.
Just that.
We are
this
not
was
well versed
any
on
of the
these news in
computable offense.
the amendment.
It will take some time.
Yes, even it's to some extent difficult, my lord. 352, my lord. Lordship got it.
Yes.
Now, intentional insult with intent to provoke breach of peace. That was the my lord, the heading. Whoever intentionally insults in any manner and thereby gives provocation to any person, intending or knowing it to be likely that such provocation will cause him to break the public peace or to commit any other offense, shall be punished with such and such. My lord, may I be very candid? This is a non-cognizable, my lord, and the non-bailable. 352.
নন বিলেবল
Non-bailable, non-cognizable. Now, 353. 353, my lord, these sections which has been added, 353 subclause 1, B, C, and 2. This has been section added. Now, 353 kindly come. Statements conducting to public mischief. 1. Whoever makes, publishes, or circulates any statement, false information, rumor, or report, including through electronic means. So, 353 subclause 1, my lord, is well attracted. My lord, then B and C. Next page. With intent to cause or which is likely to cause fear or alarm to the public or to any section of the public whereby any person may be induced to commit an offense against the state or against the public tranquility. And similar, with intent to incite or which is likely to incite any class or community of persons to commit any offense against any other class or community. This section is non-bailable and also cognizable. Cognizable. And 353 subclause 2, whoever makes, publishes, and circulates any statement or report containing false information, rumor, or alarming news, including through electronic means, with intent to create or promote, or which is likely to create or promote on grounds of religion, race, place of birth, residence, language, cluster, community, or any other ground whatsoever, feelings of enmity, hatred, or ill will between different religions. This is also, my lord, the non-bailable and cognizable. Now, my lord, kindly examine the 267 section. Who 67, Lordship? Lordship got it? Yes. 267 is, my lord, intentional insult or interpretation to public servants sitting in judicial proceeding. Whoever intentionally offers any insult, causes interaction to any public servant, while such public servant is sitting in any stage of a judicial proceeding, shall be punished with simple imprisonment for a term which may extend to such and such. This is also, my lord, non-cognizable and bailable offence. So, my lord, here, out of the three sections, two are non-bailable, two are cognizable, one is non-cognizable offence. My lord, in section, which is, my lord, CRPC, in BNS 174 section said, BNS is 174 subclause 4 says, where a case, what I'm reading, and where a case relates to two or more offences of which at least one is cognizable, at least one, the case shall be deemed to be a cognizable case, notwithstanding that the other offences are non-cognizable. So, my lord, here, by the affair of 13/9/2024 discloses the cognizable offences. Discloses the cognizable offence. The moment on 13th September they disclosed the cognizable offence, police had registered this affair under these sections. Because, Lord, it is the duty of the police, it is the law of the land. The moment the cognizable cases has been disclosed, immediately has to be registered. An investigation to be carried out in terms of the procedure. So, police had done this, and then in consequence, they had to, my lord, issued a notice for his appearance to substantiate and to produce some documents. That notice was issued, my lord, on 16/9/2021. I have annexed.
Page 18.
My lord, must be, yes, right, your lord, yes.
So this is 13/9.
13/9, asking him to appear on 16/9, my lord. That is, your lordship will find 1, 2, 3, 4, 5, 6 line. You are directed to appear.
Yes.
That's why I said, because I'm skipping, my lord, that 16/9. But in the reply through a mail, he said that I need a more time. And then he sought for a time.
Anyway, documents were sought for from this person.
Exactly. These
How
are the
many documents did you
A, B,
seek?
C, D, F.
A, B? No, not A.
You will not commit any offense in.
No, which document?
Lordship, it's a completely wrong statement made.
how many documents?
35(2) notice
Milord,
was
huh?
issued.
How many documents did you
Lordship
seek
is
from this
being-
person?
My lord, I am coming. 16.
Lordship,
You will produce
35(2)
all relevant
notice was
documents.
issued.
My lord, I am coming.
I expect the submission.
Please
to
don't
be fair,
interrupt me in
Lordship.
this way. This is not the way to.
But that
address
is
the
not the
court.
way to misguide the bench. Please
Anyway,
say
please
that
submit.
35(2) notice was issued.
Mr. Chatterjee, we
Lordship.
will not decide this case ex parte. If we at all decide, we'll
Lordship.
hear you.
My lord,
Point out.
that-
You point out whatever erroneous submission is made on behalf of the appellant. As it is very difficult to hear you virtually. You are not very clear. The sound quality is not very good. Please don't interrupt. We'll hear you. If we decide the case, obviously we'll hear you.
Now you see, you have
Milord,
stated
yes,
that you
kindly-
will produce all
Milord,
relevant documents
Yes,
for
my
the
lord.
purpose of
It
investigation.
is for the purpose of, my lord, the investigation, my lord.
So,
These are the direction were given, police.
definitely, but actually, you see, some specific documents.
It
are
was
sought
not,
for.
my lord, because kindly see on 13th we received and then 13th the notice was issued. That's why we will examine, we will carry out the investigation.
Yes,
This is
yes,
the reason.
the person
So,
will appear.
Exactly, my
You
lord.
will
That's-
also
This is not,
comply with everything you will do.
this is not a case, my lord. This is not my case.
Documents.
Yes, so notice was issued to him, and then definitely he has sought for a time. Then, my lord, on 20/9/2024, my lord, he has filed this petition
Yes,
before
which
this honorable
page?
court.
Okay.
On 17th,
Challenging this notice
challenging the
Yes.
notice and affair.
and if I.
Affair for quashing. Read file for quashing of the affair and challenging the notice on 17th itself the next day.
And the learned judge has quashed it.
Not
No.
quashed it.
Interim,
That
any- what is the interim order
Yes.
passed?
Now, my lord, kindly come to the order impugned. My lord, first, before I come to the impugned order, I would like to hand over the in between the order passed by the learned judge, my lord, court below. My lord, may I hand over the two orders? My lord, sorry. My lord, kindly turn out the second my lord, page. That is the order which I have handed now just now. The order dated 25th September 2024, my lord.
Yes.
20th September, my lord, second running page. The very first day, my lord, the police are restrained. Lord, you got it, the last from bottom.
Page 25/9, that is 25/9.
No, my lord.
Order dated.
Order date 25/9.
Yes.
Second page.
Internal page 2,
Page 2.
second last paragraph.
Page number, Lordship.
The police are restrained from taking any step in
So
response to subject
which page you are referring
affair
to?
till 4th. affair till 4th October 2024 until further order, whichever is earlier. So, my lord, in the 25th September, so FIR was registered 13th September, notice issued on 13th September, asking him to appear on 16th, 17th he filed a repetition, 25th there is an order of a prohibitory order from the learned court, my lord. Now, my lord, what is the order into? MAT, it has been annexed. My lord, I will skip, straight away I'll come to page 3, running page 3, my lord, of the order annexed in the MAT. My lord, Justice Chaudhary, I think,
Yes, page.
My lord, the order.
Okay, this is the impugned order.
Yes, my lord, impugned order.
So certified copy must be here.
Yes, yes, the running page 3, MAT, it has been annexed to the MAT, my lord.
Yes, running page 3,
Page 3, paragraph 10 of the said order, my lord.
paragraph 10. Yes.
As regards the complaint filed by Otri Sharma, it appears that the entire allegation revolves around the judicial proceeding suo motu taken up by the Honorable Supreme Court in connection with a brutal incident which took place in the Arjikar hospital. Several mass protests and agitations are taking place in the state, country, and even beyond the boundaries of the country from the very next day of the incident. There are various versions of the incident that are doing the rounds. The manner in which the general public has got themselves involved in the mass agitations reflects the views of the public in general and not of an independent individual. Then, 12. I'm skipping paragraph 11, 12. The court has conversed with the de facto complainant, Otri Sharma, who was present virtually. In the earlier order, he directed to appear virtually or personally. He disclosed himself to be the legal practitioner and submitted that he was concerned with regard to maintaining the dignity and majesty of the judiciary. Then, kindly come paragraph 14. The court is not at all convinced how court has arrived. There was no case diary even called for, no daily diary even was produced, nothing. But court said convinced that there is any likelihood to cause fear or alarm to the public or to any section of the public to commit an offense against the state or against the public tranquility by the act of the petitioner. The right to free speech ought not to be curtailed by putting threat on individual to initiate criminal proceeding. According to the learned judge, FIR lodging is a threat.
Yes, yes.
15. The instruction forwarded by the inspector in charge Siliguri police station, it has been instruction to me, Mila. In connection a case number such and such, does not mention whether the public or any section of the public committed or tried to commit any offense in furtherance to the video which was uploaded by the petitioner. Mila, that would be reflected in the CD case diary. It is a mirror. It was the instruction from the police station, the police personnel, that this is the progress of the investigation, which I have handed over to the learned judge. Now, paragraph 60. As regards the allegation of airing offensive, defamatory, and menacing report against the Honorable Chief Justice of India, the police could not have taken steps in response to such allegation till there is any complaint lodged by either by the Honorable Chief Justice of India or upon instruction of the Honorable Chief Justice of India. With regards to 267, that is the Honorable Chief Justice of India. If he is being aggrieved, then he can file. But here the section, even in the Honorable Supreme Court, even in other the false and the malicious video uploaded in the same issue, the cases has been initiated by the Honorable Supreme Court, even at the instance of the Honorable Chief Justice of India. So, 267, the person being aggrieved, the Honorable Chief Justice, definitely. But section with regards to the 353 subclause 2, 353 B.
Yes, what is there? 353.
Which I have read.
That is the cognizable and non-bailable.
Cognizable, non
353.
353.
Yes, 353.
2.
No, 3.
353. 353 B.
353 B.
1 B. 1 B.
Yes, so that is cognizable
Yes.
and non-bailable.
Yes.
No, here you see, this is an admitted position. There is derogatory remarks upon the Chief Justice, interference in the administration of justice. Definitely, on the face of it is appears. But how far this section is applicable? That is the only question.
353.
Yes, yes.
That is the police to investigate.
No. How
That
far?
police will, that is the
From-
court
no,
cannot
from
sitting
the-
over the
From that allegations.
kindly
whether
353
this-
one again I'm reading
whether
B.
that section is
B.
undoubtedly it's a derogatory
B,
remark.
B, kindly read B. With intent to cause or which is likely to cause fear or alarm to the public or to any section of the public. So, by of this circulation, that is a cause of fear or alarm to the public, whereby any person may be induced commit an offense against the state or against the public tranquility. Similar 2. C, sorry, with intent to incite or which is likely to incite any class or community or person commit an offense against any other class or community is a provocative. 2. Whoever makes, publishes, circulates any statement, report containing false information, rumor, or alarming news through electronic media. So remember, this is the reason 353 subclause 2 is well attractive.
Where is the other section which you relied?
267(1).
267.
That is upon the person being aggrieved, the Honorable Chief Justice. There are 2-3 sections has been incorporated.
Yes.
One is cognizable, 2 is cognizable, 1 is non-cognizable. I said from this section that if the one section is a cognizable offense, then other would be deemed to be a cognizable. So, my lord, when the cognizable offense has been disclosed, it is the duty incumbent of the police to carry out the investigation. May I read further sections? So now come to the judgment, my lord. My lord Justice.
Yes.
No, my lord. I read 16, my lord. Now, my lord, 18. Though the court is not appropriate authority to advise as to how the police should deal with such complaints, but the court feels that the police have far more important issue to handle rather than spend time on complaints which do not disclose any proper offense and are more to gain public attraction. Because whether the offense has been disclosed or not, prima facie it has to be seen. The moment it has been prima facie has to be seen, police shall carry out the investigation. After causing an investigation, if it's find the genuinity of the complaint, end it with the charge sheet or end it with the FRT, whatever. That is the prerogative of the police with regards to carry out the investigation. 19. The court is not inclined to permit the police to proceed any further with the FIR that had been registered in response to the complaint filed by Otri Sharma. Malad, here I am agreed. Next, I am agreed. Very peculiar, Malad. The respondents are directed to file an affidavit disclosing the necessity to proceed with such complaint in a mechanical manner without proper application of fine. Date is 22nd/11/2024. So, Malad, in one hand, investigation has been stopped after 10 days, my lord. No investigation could progress. By an order of this honorable court, my lord, say police cannot proceed with the investigation. In the other way, I have to file an affidavit disclosing the necessity, how I will. Because now in the meantime, what police had done within the 7 days, Lord, he has seized the pen drive, which the complaint has through a pen drive, which has been supplied to the authority. First, he has made a seizure. Then, my lord, he has done. May I hand over the what he has done in subsequent to that? Just 2-3, because a very short period, my lord. Very short period. Within that period, what police has done? The cyber crime, 1, 2, 3, 4, 5, 6, 7, 8. First is seized. Seized also got it seized 1. Column number 1. 1, 2, 3, 4, 5, 7, 8, 9 line. 9th line. First page.
Yes.
9th line, seized, Roman 1. One pen drive containing video footage of YouTube post by such and such person.
You seized from whom?
From the complainant. Then 2, seized. Then what? Subsequently, what he has done? Cybercrime PS, Siliguri Police Commissionerate, for supplying the details of social media site YouTube. That is below the YouTube portal's code. Then why Matigara PS number such and such? In response, Inspector in charge Cybercrime PS sent a mail to the administrator YouTube LLC 901 Cherry such and such, requesting the authority to provide the YouTube account details having URL number by the office memo number dated 14/9/2024. Till then, my lord, this has been carried out. Thereafter, because of the matter is in season before the honorable court, my lord, thereafter we could not progress further, my lord. In the meantime, now, my lord, there is an embargo that police cannot proceed with the investigation. I am agreed by 1. Number 2, if I cannot proceed with the investigation, how I will file the affidavit disclosing the what actually happened is my Justice Chaudhary's query, whether the section of 353 is being attracted or not. Then with this, my lord, whether this genuinity of the social media, the contents of the say YouTube contents which has been uploaded. So, my lord, now, my lord, because I'm constant of time, my lord, straight away I will refer a judgment, my lord. That is a 2021-19 Supreme Court 401. Before that, I am just referring the Lolita Kumari well-known case, 1 paragraph. 2014, 2 Supreme Court cases. Still 2024, the constitutional bench order is Lolita Kumari. Kindly come straight to the last page, page 61 of the same chapter, Lolita Kumari. Now
Yes.
she's got it. Conclusion directions.
Page.
Last page. That is 61.
It's
Conclusion direction. That was the direction. What direction say? We hold the registration of FIR is mandatory under section 154 of the code if the information discloses commission of a cognizable offense and no preliminary inquiry is permissible in such situation. Then we are skipping 120.4. The police officer cannot avoid his duty of registering offense if cognizable offense is disclosed. Action must be taken against the erring officer who do not register the FIR. The information received by him disclose the cognizable offense. There are other conditions, guidelines. I do not wish to state further. So, the police authorities, the moment they disclose the cognizable offense, register, started investigation. That has been stalled. Now, my lord, 2021 Niharika, my lord. Landmark judgment, my lord. May I hand over? My lord, in 2023, the Honorable Justice Bela Trivedi and my Lord Justice Dipankar Dotto has also reiterated the same fact with regards to the my Lord Lolita Kumari, which I am not handing over because same fact has been reiterated in 2020.
FIR has to be registered, but from the FIR, whether an offense is made out or not, yes, definitely the police authority has acted in accordance with law. They have registered the FIR. But now, in any FIR, you see, it is always subject to challenge, whether it should
I'm
be
not here.
sustained or quashed or whatever it is.
I'm not here.
Yes,
That is always within the domain.
police authority cannot be blamed for registering the FIR.
No. But the only mere registering of FIR
Yes,
cannot culmination into the conclusion of a investigation.
yes. Sometimes you see so many offenses, you see so many cases, FIRs are registered, that FIRs are challenged, that it does
Always.
not disclose the offense, or
Always.
whatever it is.
Always, they challenged it. Now the question is
Yes.
under the judicial scrutiny,
Yes, whether
Whether
it's
the-
26 or any other revision.
whether the
corrective-
investigation police, if the court can stall the investigation at the very nascent stage. This is my challenge.
Yes.
This
Yes,
is 2021 from our Supreme Court. Milord, straightway kindly come the running page 447. Lordship got it, paragraph 19.
Yes.
As observed herein above, there may be some cases where the initiation of criminal proceedings, here, my lord, I will perhaps would be able to satisfy your lordship query. Where the
Which judgment
initiation
Lordship is referring to?
may be an abuse of process of law.
Lordship, may,
In such cases,
Lordship, may I know which judgment is referring to?
Yes, sure.
I'm sorry, I'm referring the full.
I'm sorry to interrupt.
2021 19 SCC, page 401.
Hmm. What was it? What was it?
In such cases, and only in exceptional cases, my lord, kindly mark, in exceptional cases, and where it is found that non-interference would result into miscarriage of justice, the High Court, in exercise of its inherent power under Section 482 and Article 226 of the Constitution of India, may quash the FIR complaint, criminal proceedings, and even may stay the further investigation. However, the High Court should be slow in interfering the criminal proceedings at the initial stage. That is, quashing petition filed immediately after lodging the FIR complaint, and no sufficient time is given to the police to investigate into the allegations of the FIR stroke complaint, which is the statutory right, duty of the police under the provisions of the Code of Criminal Procedure. There is no denial of the fact that the power under Section 482 is very wide, but as observed by this court in a scatena of decision referred in herein above, conferment of wide power requires the court to be more cautious, and it casts an onerous and more diligent duty on the court. Therefore, in exceptional cases, when the High Court deems it fit, regard being had to the parameters of quashing and the self-restraint imposed by law, may pass appropriate interim order as thought opposite in law. However, the High Court has to give brief reason which will reflect the application of mind by the court to the relevant facts. It is completely absent. Now, my lord, kindly come page 455, 454, my lord. Four, 33 paragraph.
Yes.
In view of the above and for the reasons stated above, our final conclusion on the principle or core issue whether the High Court would be justified in passing an interim order of stay of investigation and or no coercive steps to be adopted during the pendency of the quashing petition under Section 482 or Article 220 of the Constitution of India, and in what circumstances and whether the High Court would be justified in passing the order of not an arrest the accused, no coercive steps to be adopted during the investigation or till the final report stroke charge sheet is filed under Section 173 CRPC, while dismissing, disposing of, not entertaining, not quashing the criminal proceeding, a complaint affair in exercise of power under Section 482 CPC or 226. Our final conclusion are as 33.1, very important. This is my case here. Police has the statutory right and duty under the relevant provisions of the criminal procedure contained in Chapter 14 of the Code to investigate into a cognizable offence. Courts would not thwart any investigation into the cognizable offences. Next, it is only in case where no cognizable offence or offence of any kind is disclosed in the first information report, the court will not permit an investigation to go on. Here it is not the case, my lord.
That is 33.3.
3. 33.4. Power of quashing should be used or exercised in the rarest of rare cases, not to be confused with the formation in the context of a death penalty. A separate aspect. 5. While examining an FIR complaint, quashing of which is sought, the court cannot embark upon an inquiry as to the reliability of the genuineness or otherwise of the allegation made in the FIR of the complaint. 6. Criminal proceeding ought not to be scuttled at the initial stage. Then exception ordinary rules state 8. Ordinarily, the courts are barred from usurping the jurisdiction of the police. Since the two organs of the state operate in two specific spheres of activities and one ought not to be trade over the other sphere. It should like a railway track, my lord. The functions of the judiciary and the police are complementary, not overlapping. Then 12. The first information report is not an encyclopedia which lordship even expressed half an hour before, which must disclose all facts and details relating to the offence reported. Therefore, when the investigation by the police is in progress, the court should not go into the merits of the allegation in the affair. Police must be permitted to complete the investigation. It would be premature to pronounce the conclusion based on hazy facts that the complaint affair does not deserve to be investigated or that amounts to abuse of process of law. After investigation, if the investigating officer finds there is no substance in the application made by the complaint, the investigating officer may file an appropriate report with summary. Then 33.15. When a prayer for quashing affair is made by the alleged accused and the court, when it is exercised power 482, only has to consider whether the allegation in the affair disclose commission of a cognizable offence or not. The court is not required to consider on merits whether or not merits of the allegation make out a cognizable offence, and the court has to permit the investigating agency police to investigate the allegation in the affair. Then, my lord, last paragraph 33.16. The aforesaid parameters would be the applicable and the aforesaid aspects are required to be considered by the High Court while passing an interim order in quashing petition excess of power 482 or 226. However, an interim order or stay of investigation during the pendency of the quashing petition can be passed with circumspection.
So you have completed,
I
Mr.
understand.
Chaudhary. Without hearing Mr. Chatterjee, we cannot pass any
Definitely
order.
that cannot be, my lord.
Yes. So therefore, what to do? Interesting matter. I have at least.
Can I argue before your lordship there in Calcutta?
No, then we'll have to make it part heard.
Well, because already a substantial part I have completed. 90% I have finished.
You have finished. He has not even started.
These are the hardened parts.
He has not even started. Mr. Chatterjee has not even started.
Otherwise, my lord, the court's time would have been, it has been.
No, we enjoyed listening to you.
That would be for academic purposes. No problem.
I learned about this case. This is very helpful.
Very, very interesting case, even. Very interesting.
This
Nyarika.
three-judge judgment.
So, my lord, kindly make it part hard. I will, my lord, otherwise, my lord.
No, Mr. Chaudhary, the higher authorities frown upon that. I'm telling you. And we have to face the music. You understand when I say higher authorities?
I got it. Certain administrative authority higher.
So-
No one is higher than
Yeah.
in judicial proceeding,
No.
my lord. Here in the state of my lord.
We can't pass any.
My lord, 15 minutes can be spared tomorrow. Definitely subject to.
No,
I
but
cannot
then only hearing you will not serve the
then
purpose.
deserve the judgment, my lord. But otherwise,
No, Mr. Chatterjee,
No, Mr.
will you
Kumar-
finish in 15 minutes?
tomorrow, my lord.
It is difficult. To a certain extent, it is difficult, Lordship, because there are, I will be arguing on the what point I am telling you, Lordship. Mr. Chaudhary has already referred to the sections of this Nyaya Samhita. I will be referring to the sections from the Nagarik Suraksha Samhita, which clearly gives some impediment upon the police regarding the offences committed against the judiciary or judicial officers. There is a clear embargo. The police cannot, magistrate cannot take cognizance from that.
Sorry,
So there
let
is
us
a
record an
conflict on
order.
that.
We had,
Matlab, I have disclosed my all.
sorry,
And
Matlab,
Lordship, that if
protected
Mr.
by an interim way, because the report we have to file by 22nd 11.
affidavit.
Affidavit disclosing. Matlab, may I very candidly I will submit. I will not arrest him. Allow me to cause an investigation and I will submit the report.
No,
I will not
that,
arrest him. No coercive step with regards to any arrest. I will not. I am giving an undertaking. But permit me because no court can snatch my power.
Lordship, the
It's my
question
statutory
is,
power.
we may
That's
well
where
agree
Lordship
with
has to
you.
show.
Again, without hearing him, can we
Where
pass
is
such
it?
an
Then
order?
22nd I have to file. Otherwise,
No,
I can face
that we are thinking what we can do.
that kindly protect me in that scope.
Lekho. Today is the penultimate day of this circuit. Stop. Tomorrow, only criminal matters will be taken up. That too, in the first half, as in the second half, both of us propose to sit singly. Stop. Paragraph. With the ardent hope that hearing would be concluded